everyone. Welcome to the MPRE webinar. I'm Melissa. It's nice to meet all of you and welcome to the webinar. Any questions regarding content that I talk about today, go ahead and put in the Q&A and I'll answer those questions at the end once we get through all the material. All right, so let me share my screen and we will be ready to go. Today, we are talking about MPR traps, avoiding wrong answer choices on the MPRE. So what we're really going to talk about today is how to choose the best answer. So even though there's a lot of content, black letter law, the ABA rules that you need to know, there are some strategies where you can eliminate one or all three wrong answer choices to get to the best answer. So that's what we're really going to focus on today. Why BarMax tutoring? Well, tutoring gives you that one-on-one little bit of extra push you might need to understand concepts, accountability, strategies, identifying strengths and weaknesses, and how to deal with that to be successful on your exam. And this slide tells you a little bit about our pricing and anything else you can refer to Katie about, but it's really something that can push your studying over the edge in order to successfully achieve a passing score on the MPRE. Before we talk about our strategies, let's talk a little bit about the MPRE basics. So what is the MPRE test? Let's kind of refresh our memory, even though I'm sure you've started studying, maybe you haven't, but let's go ahead and refresh our memory. It tests the ABA model rules and it tests the ABA model code of judicial conduct. It also tests controlling constitutional decisions and generally accepted principles. What does that mean? These are rules that have come through case law, through accepted practices, but mostly it's based on the ABA model rules. And sometimes some of these leading concepts will be in the comments if you go ahead and read the rules. But what you really should do is see the rules and practice the questions. That's how you're going to be successful. And that's what we're going to talk about in a few minutes. But this is the basics of what you're going to be tested on. The exam is 2 hours. It's 60 multiple choice questions, and it's administered by Pearson VUE, and it's taken on a computer. It's a computer-based exam. Now, what everyone is concerned about is their score, right? So scaled scores range from 50 to 150. Each jurisdiction has their own passing score. So those range from 75 to 86. 86 is the California score that's required. Now, how do you achieve this scaled score? Well, what does the NCBE do? They take your raw score, which is the number of questions you got right. So 1 out of 60. So how many you got right, and they put it in a statistical process known as equating. What's equating? Well, it's a fancy word that just means that they statistically want someone not to be punished or rewarded by taking an easier or more difficult exam. So over a period of time, they equate those exams so that everyone takes the same amount of difficult a level of an exam. So we don't know exactly how many answers you need correct to score a passing score because the equating, the statistical process is always a little different. So how do you know what you need? Well, generally a score of an 85 is about 60% correct. We know that just from statistics and seeing the scores throughout the years. So what does that mean? It means that if you score approximately 60 to 65%, you should achieve a passing score. That equates to about 36 out of 60 correct. Remember, this is not an exam that you're expected to get 100%, 90%. We're trained as A-type personalities to want to achieve that perfect score, that near perfect score. That's not what this exam is about, and that's not what you need. You need to be about 60%, 60 to 65 would be fantastic to guarantee you, guarantee is a strong word, to most likely achieve a passing score. Remember that we don't know for sure because of the statistical process, but obviously you want to have as many correct as you can, which will then lead to a passing score. How are you going to study, or how should you study for the MPRE? Well, you're here. So my guess is you've been using the BarMax MPRE course, which I'm so happy. It's free, right? That's our gift to you. Now, what should you do with our free course? It has great lectures that are just the right length. It has about 160 free practice questions. Those you should do open book. That's our active method of studying. Our active studying means that you use our lectures and our outline to look up the rules to answer the questions. That's allowing you to use the material, to apply the material in an active way for better retention. If you're simply reading outlines, listening to lectures, and then trying to recall all that information, you're only retaining a very small percentage. So with active studying, you want to use the outline at the beginning, find the rules, apply them to your questions, and then answer them. That's how you're going to retain a lot more information and understand how the questions are asked and what they're expecting you to answer and how to answer the question, because they're written in a particular way. That's why you want to use these real MPRE questions. That's also what's found in the BarMax course. Now, there's also 2 practice tests that you can purchase. Now, the NCBE has these 2 practice tests. They are $50 a piece. We sell the same questions for $24.99 each. So they're half price. So if you've already bought the NCBE questions, these are the same, so you don't need to purchase them again. If you have not purchased them, go ahead and you can purchase them from us. They're 50% off, essentially. They're $24.99 each. Now, with how to study, how are you going to approach each of these multiple choice questions? So here's a method we like to use in order to best use the open book method, the active studying method, and also allow you not to be distracted by some of their answer choices. So the first thing you want to do is read the call of the question, which is when we go to our practice questions, we'll do that first. That's going to give you a good indication of what your issue is. What are you trying to decide? Whether the attorney is subject to discipline or something else. Or can they be sued? What the best course of action is? Who knows? So that's what you want to first focus on, the actual question that you're being asked to answer. Then read the facts. What's happening? What's the attorney doing? What's the client doing? What's going on? Once you've read the facts, then think about the rule, the issue, and then what's the rule? During your practice questions, you're going to look that rule up in your outline and apply it to your facts. When you do your practice questions, that's what you can do closed book using just your memory recall. And you're going to apply the rule to the facts and come up with your answer. Then you're going to look at the answer choices. Select the best answer that fits your analysis. Why are you waiting to look at the answer choices to the end? Well, because it helps you avoid choosing the answer that's a distracting answer, but it's written so it sounds good. If you cursory read the answers and go, that sounds good, that sounds like that's the correct answer, and you choose it, did you do any analysis? No. Did you think of the rule? Did you apply it? No. And that's where you can get a string of wrong answers because, hey, you haven't actually been doing the analysis. And it's something that you unconsciously can fall into. So by having the process in place and practicing that, you will avoid choosing the distractor answer because it sounds good. Okay. Another tip that you need to focus on is focus on the attorney's conduct. So the question can talk about substantive law. It can talk about lots of different things that are happening in contracts, in torts, in wills, all the different areas of substantive law. But if the answer choice focuses on substantive law, that's probably not the best answer choice. If the information in the answer choice is not relevant to the attorney's conduct and behavior, it's typically a distraction, and it should not be the basis of your answer. You need to focus on answering the question asked, which relates to the attorney's conduct and whether it's ethical or not, typically, whether the attorney is subject to discipline. So remember that this is an exam testing the standards of professional responsibility. Do not get bogged down in substantive law. Second, you need to think about what can the lawyer do without being subject to discipline. So what you want to avoid is picking the answer that is the perfect lawyer answer. No one's perfect. What you want to pick is the answer that avoids getting in trouble. The attorney can come up to that ethical line, but what conduct would cross that line? That's where you want to learn and pick the best answer that doesn't cross that line. Especially if the question asks, what can the lawyer do ethically? Or is the lawyer subject to discipline? You need to then evaluate whether the lawyer crossed that line or not. Well, let's take a look at an example of that. So let's go ahead and read the question. The attorney prepared a will for client and acted as one of the subscribing witnesses to client's execution of the will. The will left all of client's estate to client's son. Later, at client's request, attorney prepared a second will for client and acted as one of the subscribing witnesses to client's execution of the second will. The second will left one half of client's estate to son and the other one half to housekeeper, client's housekeeper. Client died and housekeeper has offered the second will for probate. If son requests attorney to represent him in opposing probate of the second will on the grounds of fraud and undue influence, is it proper for the attorney to do so? So let's look at our answer choices. Let's apply our rule. What's the issue? Let's think about that first, because that's our process. What's the issue? Well, can attorney represent son and opposing a will that he essentially facilitated the execution of? And he's attacking the validity of the execution. Attorney here is what? Going to be probably a witness because he's the only one who was alive since client has died, can speak to fraud and undue influence. Therefore, it seems like attorney should not be able to take this representation because he's going to be needed at trial if it goes that far. So let's take a look at our answer choices here. A, because after client's death, attorney may represent son. Okay. Maybe. The answer is maybe. It doesn't really talk about a rule, right? So our rule said that, it's probably not. We don't like yes, because yes is not he can't, because again, they're attacking the execution. He's a necessary witness. So A is not a good answer because it doesn't relate to any of our rules of professional conduct either. That doesn't really mean anything when it relates to the basis of Son's argument against the probate of the will. B, yes, because Son is a beneficiary under both wills. Well, does this relate to the attorney's conduct? Not really. The Son being beneficiary under both wills has nothing to do with whether or not attorney can represent him. It may have something to do with whether he can address the validity of the second will, but that's not why we're here. This is not a wills exam. This is a professional responsibility exam. So B can be eliminated because it doesn't focus on the attorney's conduct. It's not what you're being tested on. We want to finish the question here. Let's look at C. No, because an attorney guarantees the validity of a will that he or she prepares. Well, there are no guarantees. This is an example of another type of wrong answer choice, which means it's too broad and misstates the rule. There's no guarantee of anything when an attorney prepares a document. So this is a wrong answer choice because it misstates a rule, because that's not the rule, and it's overbroad and uses absolute terms with guarantee. There's no real guarantees. We all know there's exceptions to rules. So C, we can also eliminate. And D, well, we've eliminated all the other answer choices, but you still have to make sure that it fits. No, because attorney would be taking a position adverse to a will she prepared and witnessed. Well, you can't. That is the most reasonable. It makes sense. And it's part of the rule that if you're a necessary witness, you can't then be in a position that you're an adversary to the position that you're going to testify about. So D is your best answer here. Right. Let's take a look at our other eliminating wrong answer choice strategies. First one, wrong rule statements. The answer choice has the wrong rule in it. It's just the wrong rule. Just like we said with guarantee, that's not part of the rule. So when you have that, you can eliminate that as a wrong answer choice. An answer is either too broad or too narrow. You're more likely to see an answer that's too broad, but it could be too narrow. So I don't want to eliminate that as part of a strategy to eliminate wrong answer choices. But it could, usually they're too broad. They don't encompass exceptions. They use too big of words like guarantee. That's too broad. And that's not usually going to be a right answer. The answer choice can also use absolutes. Any, all, never, none. Those are usually not right answer choices because, again, there's always exceptions to the rule. There's hardly any absolutes in the law and in professional responsibility. So you want to avoid that. There also can be misstatements or confused facts, right? So you read the facts and then the answer choice doesn't match with the facts or it mischaracterizes them, then that's most likely going to be a wrong answer choice. The answer choice could misapply the rule. So you know the rule, you identify it in the process of reading the question, and then there's a misapplication because that's not the reason. That's not how that rule is applied. That's not going to be the correct answer or the best answer choice. And the last one is avoiding unfamiliar terms. Now, in your course studies, you could probably see some words that you have never come across. This should not be an automatic elimination, but you should think about whether or not this word has ever come up. Have you ever seen it? And if you haven't, be reluctant to pick it. So go over the other answer choices. Are there better ones? If there are, that's probably the better answer to pick. So you want to avoid those unfamiliar terms. And we'll see an example of that in a second. So let's take a look at an example of wrong rule statements. So let's read the call of the question first, because that's the beginning of our process. If the attorney accepts the representation, is the attorney subject to disqualification? So here the question is asking, is the attorney subject to disqualification? That's what we should always keep reminding ourselves when we're looking at our answer choices. And we're trying to figure out what rule we're going to apply. So let's read the facts. 5 years ago, an attorney represented a seller in the sale of the seller's home. The attorney has not represented the seller since that time. Recently, the attorney was approached by the seller's partner in a venture capital company formed 2 years ago. The partner and the seller have agreed to dissolve their partnership, but cannot agree on the terms of the dissolution. The partner had asked the attorney to sue the seller for an accounting of partnership assets. Okay, so is the attorney subject to disqualification? So what's our issue here? Well, we have a potential conflict of interest with a prior client, because 5 years ago, he represented seller in the sale of his home. Now he's being asked to represent another party against his former client. What's the rule for that? Well, again, if you're doing this open book, you're going to look up the rule. The rule is that a lawyer who has formally represented a client in a matter may not represent another person in the same or substantially related matter in which the person's interests are materially adverse to the interests of the former client unless that former client consents. Now, what are we going to do with that? Well, let's think about it. Is this new representation of partner a same or substantially related matter to the sale of the seller's home? No, it's not. Those two things have absolutely nothing to do with each other. So right now we're saying it doesn't even meet that first part. So is the attorney subject to disqualification? No. Our answer is no. So let's look at the no's. That's where you should go first, because you've already said, well, no, my analysis says no. And so then the answer is, well, which one, C or D, has the explanation that matches it? No, because the partnership dissolution is unrelated to the sale of the seller's home. Does that match our analysis? It does. It matches it fairly easily. C sounds good. Always read the other answer choices, though. Keep C as your best option at this point. D, no, unless the seller sold the home while in the partnership with the partner. Does that matter? No, it doesn't, because that's a wrong misapplication. Because just because the seller was in a partnership with the partner, it has nothing to do with the sale of his home. And it's a wrong facts. It mischaracterizes the facts, just like we talked about before, because that's not what the facts say. He wasn't in partnership with the partner when the attorney sold the seller's home. So D is not correct. But let's see, if we weren't sure of the rule and had to eliminate it wrong answer choices based on just reading them, let's look at A. Yes, because the representation is directly adverse to the seller. Well, being directly adverse to the seller is a wrong rule statement, because the rule is what? It has to be the same or substantially similar matter first and then materially adverse to the prior client. We don't even get to that part of the rule because it's not same or substantially similar to the sale of the home. So A is wrong. Why? Because it's a wrong rule statement. And if we look at B really quickly, yes, unless at the time of the sale of the seller's home, the seller agreed that the attorney would not subsequently be precluded from representing other clients in suits against seller. This is not something you can contract. Ethical duties are put in place by the rules, by the ABA rules of model, the model rules, or other rules of your jurisdiction. You can't contract for that. So B is, again, a wrong rule statement and a misapplication. Therefore, B is also eliminated just based on that rule. So we've come with C as your correct answer, and we were able to eliminate all the answer choices for various reasons. This is also helpful when you're doing active studying, because it not only allows you to understand how you apply and answer the question correctly with the best answer choice, but understanding why the wrong answers are wrong helps you understand and master the information in a different way as well. If you can explain why answer choices are wrong, then you really understand the concepts and are able to eliminate them fairly easily and efficiently on the exam. So let's take a look at another example. Here's another example of wrong rule statements. Attorney has a highly efficient staff of paralegal professional legal assistants, all of whom are graduates of recognized legal assistant educational programs. Recently, the statute of limitations ran against the claim of a client of attorneys when a legal assistant negligently misplaced client's file and suit was not filed within the time permitted by law. Which of the following correctly states attorney's professional responsibility? Now, I went ahead and read the facts because I glanced at the call of the question, which is which of the following correctly states attorney's professional responsibility. That doesn't give us very much. That's a very generic question. So we go to the facts to really figure out what we're looking at. And here we're looking at whether the attorney is civilly liable and whether or not they're subject to discipline, right? So when is an attorney subject to civil liability? Well, it's legal malpractice, right? They have to breach their duty, and there has to be a substantially likelihood of a different outcome. And they're subject to discipline when they breach a rule of ethical conduct. Has the attorney done that in this case? Well, if we focus on the ethical conduct, because remember, that's what I said at the beginning. We want to focus, this is a professional responsibility exam. So let's focus first on the attorney's ethical duties. He has a duty to what? Supervise his assistants, paralegals, everyone who assists in the legal representation. So, and associate attorneys fall into that as well. So he's going to be, did he breach those duties of failing to supervise them? It's unclear from the facts. So again, we need to find one that fills in the missing answer choice that fills in the missing information. So let's just start with A. Attorney is subject to civil liability and is also subject to discipline on the theory of respondent superior. Respondent superior. Well, that doesn't have anything to do with professional responsibility. That's employer-employee tort law, right? That has to do with employer-employee, employer being responsible perhaps for employees' tort or negligence. But again, that's not what we're being tested on. This is substantive. It's a wrong rule statement being applied and it also doesn't focus on our attorney's conduct. So let's eliminate A. Let's go on to B. Attorney is subject to civil liability or is subject to discipline at client's election. At client's election. Well, again, we thought about adequately supervising, breaching a duty of supervising your associates, your paralegals, your legal assistants. Has anything to do with a client electing that? No. And this is a wrong rule. This is a wrong statement as well, because a client doesn't have the choice to elect civil liability or whether the attorney is subject to discipline. They are two different things, and there can be both. Attorney can be civilly liable and face discipline with their state bar, or there can be neither. So it's not the client's choice. Therefore, B is just wrong. C, attorney is subject to civil liability, but is not subject to discipline unless attorney failed to supervise the legal assistant adequately. Ooh, does this focus on the professional responsibility of the attorney more than the other answers so far? And did it characterize the rule that we talked about before we got to the answer choices? Yes, because it's the attorney has the duty to supervise, and that's what this addresses. So I like C, it addresses the question. So let's look at D. Attorney is not subject to civil liability and is not subject to discipline if attorney personally was not negligent. Is that true? No, it's a wrong rule statement as well, because being personally negligent has nothing to do with their ethical duties, right? Which includes a duty to supervise. So we've eliminated wrong rule statements and misapplication of the rule, A, B, and D. So C is your correct answer because it characterizes the rule correctly. Our next example has various tools and wrong answer choices in there. And so we're going to read the question, and then on my next slide, I have the answer choices again so that we can really focus on them because the question's a little long. So let's read the call first. Is attorney subject to discipline for failing to disclose voluntarily to the authorities his knowledge of the 2 prior murders and the locations of the bodies of the victims? All right, so let's take a look at what's happening. So we're looking at, is the attorney subject to discipline for failing to disclose certain information? So we're asking, did the attorney ethically cross that line into unethical behavior? Client, who was under indictment for homicide, is represented by attorney. In the course of representation, client told attorney that client had previously killed 2 other persons in homicides completely unrelated to the murder indictment for which attorney was providing representation. Attorney, with client's consent, made a tape recording of client's confession regarding the unrelated homicides. At attorney's request, client also drew a map on which he designated the remote locations of the graves of the victims of the unrelated killings. Those bodies have not been found by the police, and client is not a suspect in either crime, both of which remain unsolved. So this is one of those Dateline questions. These questions are meant to invoke emotion in you. You have to resist that as a test taker. You are cold, impersonal. So as much as you may be outraged by the behavior of the client or even the attorney and want to make things fair, want to help the victims' families, which is a common emotion, don't. That is not how you want to answer the questions. Don't use your emotions. That is what's going to lead you to a wrong answer choice. Okay? So you need to be cool, you need to be calm, and you need to be impassionate. Okay. So is the attorney subject to discipline for failing to disclose this information about the prior murders and the locations of the bodies? When you see the word disclose, to me, it makes me think of duty of confidentiality, because that's the duty, the ethical duty lawyers have, to not disclose certain information that you learn in the course of your representation. So what's your duty of confidentiality? Your duty of confidentiality is keep any information that you, confidential information that you learned from your client during the representation, privileged, essentially. You should not disclose it unless an exception applies. So let's now look at our answer choices. I'm going to move to my next slide that just highlights it so we can see the answer choices a little bigger. So, is the attorney subject to discipline for failing to disclose that information? Well, all that information about where the bodies are, drawing a map, is meant to distract you. Because whatever the client tells the attorney during the course of his representation, as long as it's confidential and doesn't is privileged. Even if the client confessed to the murder, to the homicide that he's charged for to the attorney does not disclose that information. It's confidential, right? It's confidential information. It is the duty of confidentiality. That's the premise of the policy, because you want your client to be truthful with you. So if the client was concerned that you would go ahead and tell someone else, like the prosecutor, that he confessed, he's more likely to lie and not tell you the truth. Why is that? Why do we care? We care because we don't want clients lying to us. The only way you can effectively represent someone is if they tell you the truth, whatever that truth is. Okay? So, thinking about that, is this attorney subject to discipline? Well, let's go back to the facts one more time. Oh, there we go. When did the attorney learn about the unrelated homicides and get the map of where the bodies are? It was during the course of representation. Client told him about the other killings, and then at the attorney's request, drew a map. So is it confidential? It didn't happen within third party, and there's no third parties mentioned. So yes, happened during the course of his representation. Does it? And then you have to think, is there any exceptions? Well, there are exceptions about using an attorney to further a crime. No crime is being committed. These crimes have already happened. So on first blush, it seems like this is information that should not be disclosed, which means that the attorney should not be subject to discipline for failing to disclose it. So let's look at our answer choices, see if we can use some of our strategies to eliminate answer choices and find the best one. So A, yes, because as an officer of the court, attorney must disclose any knowledge that he has, whether privileged or not, concerning the commission of prior crimes by client. Well, reading this, there's a lot wrong with this answer choice. The first thing I want to show you is the word any, which I bolded. That's an absolute. Any, all, neither, none, never. We avoid our absolutes. You must disclose any knowledge. Well, that's not true. The general rule is you keep that knowledge confidential unless one of the exceptions applies. So that by itself makes the answer choice wrong. But let's dive just further in so we have a complete understanding of our rule and how we use our strategy. any information or any knowledge, whether privileged or not. Whoa, now it's too broad. If it's privileged, why are we disclosing it? Unless there's something else that talks about an exception. If it's privileged under the duty of confidentiality, it should not be disclosed. And if you disclose it, that's actually going to be a breach of an ethical duty. So that is overbroad. Concerning the commission of the prior crimes by client. Prior crimes of a client is not an exception to the duty of confidentiality. So here, that is a wrong rule statement. So there's 3 things wrong with this one answer choice. You can identify one or all of them to eliminate it, but it is one that is written to, it's way overbroad, and it should be, when you know the rule, you should definitely eliminate it by saying, this is not the best answer. Plus, if you do the analysis ahead of time, we already know that we're going to lean toward a no answer because we don't think the attorney is subject to discipline. But for our exercise, we're going to go through all of them. Let's look at B. Yes, because attorney is impeding the state's access to significant evidence. There's a lot to unpack here too. I'm going to bring your attention to the phrase significant evidence. What's that? Even if you've studied evidence or, significant evidence is not a standard that we typically talk about. And the state is usually looking for prosecutorially, evidence that's going to convict you. Well, great. Yeah, that's their job, but it's not the attorney's job to give it to them, right? The attorney is impeding the state's access. No, it's the state has to come up with their own evidence. The attorney doesn't have to disclose it. So this is definitely an answer that is overbroad, uses phrases that may be unfamiliar, definitely not legal concepts, and also misstates rules and facts here. There's no rule that the attorney has to provide the state with everything it knows. It's actually the reverse, right? The state has to provide the defense with their evidence and any exculpatory evidence. So it's twisting the rules around, but it's also playing on your emotions. Like I said before, you want to be able to disclose this information. So you're trying to find an ethical way to do that. Under these facts, there does not seem to be one. So B is incorrect as well. Let's look at C. No, we like no because we decided we didn't think the attorney was subject to discipline because attorney did not represent or advise client with respect to the prior crimes. Well, this is a true statement. Attorney didn't represent client at the time he committed these unrelated homicides. He didn't advise him, but does that matter? Remember, we're asking, is the attorney subject to discipline because he failed to disclose this information? The fact that he didn't represent or advise the client doesn't really reflect on whether or not he should be disciplined. So let's look at D. No, because the information was obtained by attorney in the course of the representation. Wow, that's exactly what we said. That's part of the duty of confidentiality rule. Is D a better explanation than C? Yes, because C, it doesn't really matter as long as the attorney obtained the information under the duty of confidentiality and the elements of that rule and that concept. C is sort of immaterial, the reason. So D is your best answer here, right? We avoided our absolutes. We avoided our too broad statements, and we avoided the misstatements and confusing facts that played on our emotions. So there's a lot tied into this one question. All right, let's take a look at an example of a misapplication of the rule. We've seen it a little bit at play in other examples, but here is one where there is a really good example of where the answer choice misapplies the rule that we come up with. So let's go ahead and read our call to question here. Assume for the purposes of this question only that Deft was tried, convicted, and sentenced to prison for 2 years. Must prosecutor report to the disciplinary authority his suspicions about attorney's conduct of the case? All right, so what we're taking from this is we're looking at does prosecutor have to report suspicions about the defense attorney's conduct? Let's see what happens. So we're looking at must he report? What's the rule for reporting under the ABA? So let's think about that as we read our facts. Deft, who has been indicted for auto theft, is represented by attorney. Prosecutor reasonably believes that Deft committed the offense, but because of Deft's youth, it is in the interest of justice to permit Deft to plead guilty to the lesser offense of joyriding in return for an agreement by prosecutor to recommend probation. Prosecutor has so advised attorney, but attorney told prosecutor she would not plea bargain and would insist on a jury trial. Attorney informed Deft of prosecutor's offer and advised Deft not to accept it. Deft followed the attorney's advice. Attorney is a candidate for public office, and prosecutor suspects that attorney is insisting on a trial of the case to secure publicity for herself. Okay, so now we have an attorney, a defense attorney, who says we will not plea bargain. Even though it seems like a better deal, we have a reduced charge, and the attorney suspects, or prosecutor suspects, the attorney wants to try the case for publicity. Suspects. Some of our words are real important when you're reading. So we need to figure out what's the rule for reporting. When must a attorney report another's potentially unethical behavior? Well, the attorney who knows of a violation of the rules that raise a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer must inform the appropriate professional authority, the disciplinary authority. So here, does prosecutor know of a violation of the rules? He or she suspects. He doesn't know. So I think that there is not a requirement to report. But so now, so then you're going to go into the no's if you're answering this question and see if one of those answers best fits. You always want to look at them all. We're going to go in order because we're going to look at if you didn't remember the rule or you were just going in order, you can eliminate some answer choices. So let's take a look at A, just for our exercise here. Yes, because Deft suffered a detriment from attorney's refusal to plea bargain. This focuses on what? Deft's detriment. This does not focus on the attorney's conduct. It does reference his refusal to plea bargain, but did the attorney refuse to plea bargain? No, I think that's a mischaracterization of the facts because prosecutor's attorney told prosecutor she would not plea bargain and insisted, but she did inform him of the offer, which she was required to do. So even if you suffer a detriment because you don't take a plea bargain and then ultimately lose and are convicted, that alone does not warrant a disciplinary report because bad outcomes happen. People refuse all the time to plea bargain for whatever reason, thinking you can succeed. And then something happens and you don't, right? Juries are unpredictable. sometimes. So in that respect, suffering a detriment is not enough to require report. That does not relate to the rule, right? That you have to know of a substantial question of the attorney's honesty. So we're going to eliminate A, because misapplies our rule and it doesn't really answer our question. Let's look at B. Yes, if attorney in fact received widespread publicity as a result of the trial. Well, here's a misapplication of the rule, because it doesn't matter what the result of the trial happened. If there's widespread publicity, that's a byproduct. It has nothing to do with the motivations of not recommending to accept the plea bargain and the ramifications, right? The attorney's conduct. This is a result. This has nothing to do with the attorney's conduct. So B, we can eliminate. Let's look at C. No, unless prosecutor has knowledge that attorney's refusal to plea bargain was due to personal motives. Well, let's think about our rule again. The prosecutor here has to know of a substantial likelihood that it affects their trustworthiness and their fitness as a lawyer. Well, if he knew that attorney's refusal to plea bargain was due to the personal motivations, that would definitely indicate a lack of trustworthiness and fitness to act as counsel. So C does apply the rule correctly. So let's keep C on the table and look at D. No, if attorney zealously and competently represented debt at the trial. This is definitely an example of looking at whether the attorney did something ethically wrong and or substantively, right, legally. Here, zealous and competency does relate to ethical rules, but not the ethical rule we're looking at. You can zealously and competently represent your client, but that doesn't mean you didn't violate another ethical rule. And here, as long as there is a knowledge of a substantial likelihood that you lack trustworthiness or fitness, whether it's by not zealously or competently representing your client at trial, or for some other reason, such as insisting on a trial for publicity because you're running for public office. So D is not the best answer, because it doesn't, even if there's zealous and competent representation during trial, there still can be ethical violations in other ways. So C is your better answer. So our last example today is avoiding unfamiliar terms. So remember, we saw a couple earlier, but here's where it struck me as one where I would almost be more drawn to it because it's a fancy word that seems familiar, but I don't really know what it means. So it seems like it might be the right answer. That is a common mindset that people have when taking multiple choice questions. I want you out of that mindset, because that is not how you should answer these questions. If you don't know the term, be very reluctant to pick it. So let's take a look at our call the question first. Is the attorney subject to discipline? So now we're looking at, did the attorney come up to that line or did they cross it? So let's take a look at our facts. A wife retained an attorney to advise her in negotiating a separation agreement with her husband. Even though he knew that his wife was represented by the attorney, the husband, who was not a lawyer, refused to obtain counsel and insisted on acting on his own behalf throughout the protracted negotiations. So wife is represented by an attorney. Husband is representing himself. That's what that means. The wife advised the attorney that the parties had reached an agreement. So they negotiated together and have reached an amicable agreement. The attorney prepared a proposed agreement that contained all of the agreed upon terms. Then the attorney mailed the proposed agreement to the husband with a cover letter stating the following. As you know, I have been retained by your wife to represent her in this matter. I enclose 2 copies of the separation agreement negotiated by you and your wife. Please read it, and if it meets with your approval, sign both copies before notary and return them to me. I will then have your wife sign them and furnish you with a fully executed copy. So is the attorney subject to discipline? So what we're looking at, can the attorney send these documents to the husband? Well, the answer, yes, but why? What's the rule? The issue is, can he talk to an unrepresented party? Well, here, yes, because the husband is unrepresented by choice and essentially is acting as his own attorney. So as long as attorney in our question makes it clear that he's representing the wife and not a neutral party, there can be this contact, especially when it's simply to pass on information. So let's look at, I want to point your attention to C here. C is why I included this example. Is the attorney subject to discipline? No, because the attorney acted only as a scrivener. I'm not even sure if I'm saying that correctly. What is that? A scrivener? Well, that's how I'll say it anyway. What is that? I don't know. The first thing you're going to say is, I don't know. I didn't know either. I looked it up in the dictionary. It means it's a clerk, a scribe, a notary. And I said, oh, that makes sense, because that's what the attorney actually did, because the proposed agreement was negotiated between the husband and wife, and she just relayed those terms to him. So he put them all down, put them in a nice format, and sent them off for signature. So he did act kind of as a scribe, as a notary, and not so much a notary, but as a scribe, as the person who put the agreement together. But that's not, is the attorney subject to discipline because he only acted as a scribe? Well, no, he's acting as an attorney. Either you're an attorney or you're not. And here we're looking at attorneys' behavior and conduct. If you're an attorney, you are subject to the ethical rules, regardless of what exactly you're doing. So here, just because he didn't negotiate the terms and is sending the agreement to the unrepresented husband, he's not subject to discipline because he didn't negotiate the terms. Let's look at D. No, because the attorney's letter did not imply the attorney was disinterested. I like that answer a lot more because it's showing that, hey, it's talking about communicating with an unrepresented party. The attorney is not operating under the guise of, hey, I might be a neutral party. You can take what I say. No, he's clear. I represent your wife. You can negotiate these terms, do this, do that. If you like it, if you think these terms are adequate, what you negotiate, sign it, I'll return it to you, a signed copy. But the key is because the attorney expressly said he represented the wife. He did not appear neutral. Looking at A and B quickly, just to eliminate those. Yes, because the attorney did not suggest that the husband seek advice of independent counsel before signing the agreement. Not required because the husband refused to obtain his own counsel. He's operating as representing himself. So he can essentially, as long as he's clear, he's not neutral and disinterested, he can communicate with husband. B, yes, because the attorney directly communicated with an unrepresented person. Well, that's a misapplication of the rule here, because yes, attorneys should not communicate with unrepresented people. However, husband's a party and he's choosing not to be represented. He's representing himself. It says in the facts, he insisted on acting on his own behalf throughout the negotiations. Clearly, he's choosing to represent himself. Therefore, he's sort of not an unrepresented person because he's representing himself. So that's why B is incorrect. All right, let's take a look and let's remind ourselves what we went over today. How are we going to eliminate wrong answer choices? The first thing we talked about, which is not on my list, is focusing on our attorney's behavior and conduct. If it doesn't, if the answer choice does not relate to that, it's probably a distractor answer. The other types of questions we looked at in answer choices that were wrong are wrong rule statements. Answers are too broad or too narrow. They use absolutes. They misstate or confuse facts, misapplies the rule, and you want to avoid those unfamiliar terms. So these are the strategies you want to implement using the open book method when you do your practice questions. So remember, we have about 160 that are free in the BarMax MPRE course. And you can also purchase the practice exams, which you should do closed book. So only you on the exam, timed. The NCBE charges $50 for one or $100 for two. We only, the same questions are available through BarMax for $24.99 each. So at half price. So if you don't have those yet, go ahead and look on the course and you can go ahead and purchase those. That will be able to give you a practice and allow you to see more questions that are real MPRE questions. Why tutoring? We looked at this slide previously. It's to make the most of your studying, to go over so many of your concepts, accountability, work on weaknesses, any and all questions that you have and what you're doing or content. Tutors can definitely help bridge that gap to get you to a successful passing score. All right, now I'm on my questions slide. I don't see any question. Let me see. I don't have any questions in the Q&A.
Hi, Melissa. It's Katie.
Hi, Katie.
We did have one in the chat. It was asking, is there any advice or strategy for moving quick in the actual exam due to the time constraint? Some of the questions are quite dense and take up a lot of reading time.
That's a really great question. So one thing to think about is they're going to even out over the time of the exam. So if you have a long question, you'll probably also have some shorter questions that should even itself out. But one thing to keep in mind is as you practice, perfecting your method of how you approach each question will help with efficiency as well as accuracy, if that makes sense. You don't want to have to reread a question 2 or 3, 4 times, especially when it's long. So one way to do that is if you use our method that we went through today, reading the call first, then the facts, applying the rule to the facts, and then looking at your answers, that's going to make it more efficient, which is going to be able to help with timing issues as well. So I think practicing that will help with keeping yourself on target. One thing to keep in mind, because it's 60 questions in 2 hours, you want to, when you're doing your practice exams, watch where you're at that hour mark. You should be around 30, right? And so if you're not thinking, are you going too fast? Are you going too slow? And then adjust your strategy. And that's another thing that tutors can help with is specifically addressing what your problem is or what you perceive your problem is and timing, and give you specific strategies that are unique to you to help with that. Yeah, absolutely. All right. There's nothing else. I do wish everybody, oh, I see one. Let me grab it. Okay, let's see. I have a question about fee disputes and liens. Do the attorney and client have to make an express agreement to agree to a lien? If there is no agreement, can the lawyer hold the client's money as a lien? You would need to go, offhand, I don't know. I would look into the model rules if you have that specific question and look into what they say. There are specific rules that relate to whether or not the attorney can look into and obtain a lien. But off the top of my head, unfortunately, I can't answer that. Oh, here's another one. If we want to do some last minute studying, which rules are the major ones to review? Conflict rules. This is a great question. So one thing you want to look at, and we have in the beginning, in the introductory part of the course, is a breakdown of percentages of how many questions per topic are included on the exam. And not all are created equal. Essentially, they're not all tested equally. So I would focus in part on the topics that are found the most, right? You're tested heavily on. Conflict rules is definitely one that comes up quite a bit. And then sort of tailor your priority based on the percentages. But you don't want to ignore any of those parts either, because you will see some of them and you want to be able to answer as many accurately as possible to get your highest raw score. Also, when you're doing your practice questions, you'll see rules that repeat. You'll see a pattern, ones that come up often. Those are ones that you're probably going to want to know really well because they come up often. And so they're probably going to come up on the exam in a form or another. So I think that is focusing on the questions that have the highest percentage or the sections, and then just reviewing maybe in a more cursory way the ones that have smaller sections, but don't ignore any of them as well. Because you want to make sure that you have a wide range so that you can answer, the sum of the judicial conduct questions well. I see another question here in chat. This question is will most of the MPRE answers be 2 yes and 2 no? Possibly, there are different formats, which you'll see on the practice questions. I picked the 2 yes, 2 no because it mostly demonstrated some of the strategies that we were looking at today. There are some that have what I call Roman numerals, and it's going to ask you which conduct might be subject to discipline if the attorney did them, or vice versa. Those are a little bit more tricky, only because you have to apply rules to the different scenarios that they set forth. It's not the only format you may see. When you do the practice questions, though, you'll see all the different kinds of formatted questions within the practice questions and the practice exams. All right. Thank you all for coming today. I hope that this was helpful. And if you are a future lawyer who has not taken the bar exam yet, go ahead and you can pursue BarMax. If you liked our free program, we have our bar study that is comprehensive and is something that also we have with active and passive studying. So we encourage you to do that. If you are just taking the MPRE and have already passed the bar, well, I wish you all the best of luck. Everyone have a great day.